But there is strong legal backing for our position, including the American Bar Association's opinion, which has urged federal, state, local, territorial, and tribal governments to implement the 28th Amendment.
Just over 100 years ago, a pioneering group of women proposed the Equal Rights Amendment to enshrine the principles of gender equality in our Constitution. Throughout my career, I've been clear. No one should be discriminated against based on their sex. And in order for the amendment to be ratified, it requires 3/4 of the states to ratify it. That benchmark was passed when Virginia ratified the ERA a few years ago. Today, I affirm the Equal Rights Amendment to have cleared all the necessary hurdles to be added to the U.S. Constitution now. The Equal Rights Amendment is the law of the land now. It's the 28th Amendment to the Constitution now. I consulted dozens of constitutional scholars to make sure that it was all within the power to do this. And the fact is, we did.
Good morning. Thank you for coming. Today is a historic day for women and girls who face discrimination on the basis of sex. After over 100 years of fighting, we have finally crossed the finish line. We have finally enshrined equality for women into the United States Constitution. I want to praise President Biden for doing the right thing and recognizing that the Equal Rights Amendment is already the law of the land. Now, millions of women and girls can have their day in court and fight against unconstitutional laws that discriminate against them on the basis of their sex. Of course, we know our opponents will doubtlessly challenge us in court. But there is strong legal backing for our position, including the American Bar Association's opinion, which has urged federal, state, local, territorial, and tribal governments to implement the 28th Amendment. The refusal of the United States Archivist to publish the amendment is now moot. She has no constitutional or legal role in the amending process. She does not get to decide what is or is not part of the U.S. Constitution. The purpose of the archivist is to give notice to the states that a law has passed and that the Constitution has been amended. President Biden, through his statement today, has fulfilled that duty and accomplished that ministerial step. He has functionally given notice to the states that the ERA is the law of the land. His statement alone supersedes her authority, and there is nothing left for her to do. The Equal Rights Amendment simply makes discrimination on the basis of sex unconstitutional. Discrimination like restrictions on reproductive care that single out women. It enhances protections against pay discrimination, gender-based violence, or sex discrimination in federally funded education programs or activities. It instantly provides the most effective safeguards post-Dobbs and all its attacks on women's rights and the right to privacy, and serves as a bulwark against a national abortion ban. American women have been dying because they didn't have equal protection under the law. They have been bleeding out in parking lots, in hospital beds, in bathrooms, because they didn't have access to the full range of reproductive and health care that they deserve. Child rape survivors have been forced to carry their abusers' babies to term. Women have been arrested and convicted for having miscarriages. That changes today. With the Equal Rights Amendment, we finally have the legal support we need to stop these unconstitutional attacks on women and our basic, fundamental human rights. Today marks an unequivocal victory for women and girls. The only thing we have left to do is to enforce what is now the 28th Amendment to our United States Constitution. Happy to answer questions.
So just explain, if you can, your thinking here when it comes to the archivist not acting. I mean, did he take the route that you were hoping he would when it comes to this, and has he acted to the full extent that you were hoping he would?
He has, and in fact, In fact, he has superseded the archivist. As the commander-in-chief, as the highest legal officer in the land, the archivist is part of his administration. She has the ministerial duty of publishing the Equal Rights Amendment to notify the states of the fact that it is now part of the Constitution. She should have done that from the beginning. She chose not to. She has no constitutional role and has no right to insert herself into this constitutional process. So he has essentially done her job for her. With his statement, he has followed in the steps of past presidents. In fact, President Adams was the one to publish through a statement to Congress the 11th Amendment. After it had been ratified by the states, his statement to Congress was the functional publishing of the 11th Amendment. It just needed to be done by the president, who is her boss and supersedes both her and the Department of Justice.
But in his order, or in his statement, he did not direct the archivist to do anything. Is that an issue?
She's already said she won't do her job. So he's just done her job for her. He is her boss. So instead of her publishing something in the Federal Register to put states on notice, he issued the statement that it is part of the law of the land, that Article 5 has been fully satisfied, and so he's done it for her.
Okay. What about, I've read reports that some states have retracted their endorsement of the ERA. How does that play out?
So the law on rescission is clear. States do not have the right to rescind the ratification of an amendment, of a constitutional amendment. And in fact, that has been tested in court time and time again. States tried to rescind the passing of the 19th Amendment, and that was ruled to be invalid. They tried to rescind the passing of the 14th Amendment, and that was ruled invalid. So states have no authority to do so, and the ABA has just issued an opinion saying that rescissions have no valid in the Constitution and under constitutional law.
Okay. Has a lawsuit been filed yet?
There will be many lawsuits filed, and I am calling on plaintiffs across America who have been harmed by the lack of an equal rights amendment to file a lawsuit in all jurisdictions. Women, for example, who have died in parking lots waiting to get a DNC after they've miscarried. I hope the husbands or loved ones of those deceased will file lawsuits on their behalf. I hope that any parent who has had to take their child across state lines to get access to reproductive care who have been sued and incarcerated also will sue since their rights have been abrogated under Dobbs. They don't have a right to privacy. I think anyone whose privacy rights have been denied under Dobbs or any other law, anyone who's been discriminated on the basis of sex, they should all be filing lawsuits to have their rights restored.
When do you see this I mean, can Trump do anything with this now when he takes office on Monday? And what do you see as the significance of this, in your view, being on the books with Trump returning?
If Trump decided in his first hours of the presidency to tell America's women and girls that they are not equal under the law and the Constitution, God bless him.
Are there any legislative challenges that can affect the statement by the president?
No matter any action under the ERA that had been taken, no matter what it was, whether Congress decided to say rescissions are invalid or to say there are no timelines that is not provided under Article 5, that would have resulted in lawsuits. This will result in lawsuits. Anything that moved the ERA to culmination will result in lawsuits, and that's not uncommon. In the past, when the 19th Amendment, when the 14th Amendment, there were lawsuits filed and they were adjudicated and found to be invalid. So the normal process of making a constitutional amendment, oftentimes it is litigated heavily and courts will make decisions and create precedent based on their views. But the one thing that has changed since the Trump administration is that the ABA, which is the highest legal organization in the United States, have issued an opinion saying the three things that were relevant in this debate are not impediments. They said the timeline is not valid. Article 5 does not require or allow for states to set a timeline. They didn't set it in the amendment itself, the actual amendment that has been ratified, and that rescissions are invalid and unconstitutional. So they have ruled based on all precedent to date that that is the law of the land, and that's a relevant precedent for legal scholars and courts that are now going to be adjudicating this to look at.
Are you comfortable with this going to this current Supreme Court?
At the end of the day, it is the court that we have, and our legal rights are at risk. We have done everything that the Constitution requires to create a constitutional amendment. 3/4 of the states have ratified it. 2/3 of the House and Senate have passed it. There's nothing left required. It is the 28th Amendment. And we can have litigation over this, and the court is the court who it is. And I think the precedent's on our side, so we have a opportunity to succeed in court. And so I'm going to remain hopeful, and I hope the plaintiffs across this country file lawsuits and fight for their rights.
One last thing, in just kind of the simplest terms. In terms of this now, as you say, being on the books, what does the differential look like in the day-to-day life in terms of how you view the impact of this?
It's ground shaking. It is fundamentally the greatest protection women can have, to be enshrined in the Constitution. If you go back and read the decision in Dobbs, Samuel Alito in his concurrence said that there's nowhere in the Constitution that protects women's right to privacy. There's nothing here in the Constitution. Well, now he could not say such a statement. We would have equality of the law enshrined in the Constitution. It fundamentally changes the legal arguments that women and girls can make in all areas of the law where they believe they are discriminated against. It strengthens and heightens the standard of review for discrimination in many contexts, whether it's on an equal pay context or whether it's in the context of access to life-saving health care.
What do you see as the timeline going forward? Because you're obviously mentioning there'll be a lot of court cases. When do you think this will actually be able to take effect?
It's effect now. It is in effect. States have now been notified by the commander-in-chief, by the leading voice of this administration, that this is the law on the land. And what the states are now supposed to do is they're supposed to implement the 28th Amendment. They are supposed to make sure they have no laws on the books that infringe on the 28th Amendment, and they are supposed to change their laws to reflect the 28th Amendment. So that is what's supposed to happen state by state right now.
Is there any oversight to ensure that that happens in a timely fashion?
That's what the law is for. So lawsuits should be filed by plaintiffs who feel their rights have been abrogated.
Are there any organizations out there that are lined up to do these lawsuits?
Yes, I think there's many advocacy organizations that are ready to go. Thank you.
Thank you, Senator.